Seated. I declare open the public hearing of the admissibility and merits of the case Kavala versus Turkey. The application was lodged with the court on the 18th of January 2024 under Article 34 of the Convention by a Turkish national, Mr. Kavala. The application was allocated to the second section of the court, pursuant to Rule 42, paragraph 1 of the Rules of Court. The application was communicated to the government on the 21st of March 2024. On the 16th of December 2025, the Chamber decided to relinquish jurisdiction in favor of the Grand Chamber. The Council of Europe Commissioner for Human Rights exercised his right to intervene in the proceedings by submitting written observations and taking part in the hearing in accordance with Article 36, paragraph 3 of the Convention and Rule 44, paragraph 2 of the Rules of Court. In the proceedings before the Chamber, several non-governmental organizations, Turkey Human Rights Litigation Support Project, Human Rights Watch, International Commission of Jurists, Clooney Foundation for Justice, Fair Trials Clinic of the University of Amsterdam, Thai Watch, the Union of Turkish Bar Association, Redress, and the Association for Freedom of Expression, as well as Professor Sluter, were granted leave to make written submissions in accordance with Rule 44, paragraph 3 of the Rules of Court. This authorization was maintained for the purposes of the proceedings before the Grand Chamber. On the 3rd of February 2026, I also authorized the following 7 organizations to intervene as third parties to the proceedings: European Criminal Bar Association, Media and Law Studies Association, Human Rights Joint Platform, European Association of Judges, Association of European Administrative Judges, Judges for Judges and European Magistrates for Democracy and Freedoms. The respondent government are represented by their co-agent, Mr. Edin, head of the Human Rights Department of the Ministry of Justice of the Republic of Turkey, assisted by members of his team and several advisors. The applicant is represented by Professor Leach and Professor Chali, assisted by several advisors. The Commissioner for Human Rights is represented by Mr. Michael O'Flaherty, Commissioner for Human Rights, assisted by members of his team. I welcome the representatives of the parties in the name of the court. Having consulted the agents of the government, the representatives of the applicant, and the Commissioner for Human Rights, I have determined the order of address as follows. Mr. Edin will speak first, followed by Professor Boz Bayendir for the government for around 32 minutes. Then, Professor Leach, followed by Professor Chadi for the applicant for the same time. And finally, Mr. O'Flaherty, Commissioner for Human Rights. I call Mr. Edin.
Mr. President, esteemed judges of the Grand Chamber, it's a great honor for me to address you on behalf of the government of the Republic of Turkey. Before I begin my speech, we reiterate the written observations we've submitted with the Chamber and the Grand Chamber. First of all, 2 separate individual applications regarding the complaints giving rise to the present case are currently pending before the Constitutional Court. For 13 years, the Court has recognized the individual application to the Constitutional Court as an effective domestic remedy. The applicant invites the Grand Chamber to depart from this well-established case law. Such a request demands convincing evidence. However, the applicant attempts to conclude that the Constitutional Court is ineffective by relying on different legal issues arising from different factual circumstances. The figures, however, are clear. Out of the 4,876 judgments finding violation delivered by the Constitutional Court to date, 4,868 have been fully executed. Moreover, the first application with the Constitutional Court was lodged on June 9th, 2022. The second application concerning the complaints made following the conviction was lodged on October 24th, 2023. The application was lodged less than 3 months prior to the application lodged with the court on January 18, 2024, arguing that the Constitutional Court is an ineffective remedy in respect of all post-conviction complaints on the basis of such a short period of time rests on an extremely weak foundation. As consistently emphasized in the Convention and the Court's well-established case law, the Convention system is founded on the principle of subsidiarity. If the Court examines the present case while the proceedings before the Constitutional Court are still pending, this would undermine the principle of subsidiarity. Furthermore, the applicant also raised his complaints under Article 5 of the Convention in the execution process before the Committee of Ministers. Currently, the Committee of Ministers is supervising the execution of the Court's previous judgments. The Convention system does not envisage the same matter being examined simultaneously before both the executive body and the Court. Such parallel proceedings risk undermining the institutional balance of the Convention system and may lead to conflicting assessments. For these reasons, declaring the present application inadmissible would be the solution most consistent with the Convention system. Mr. President, esteemed members of the Court, this case doesn't concern peaceful protests that are considered normal in a democratic society. On the contrary, it was an initiative planned well before the outbreak of violence, implemented step by step in accordance with a specific strategy and targeting the legitimate government. The detailed assessments made by the national courts provide an important context for understanding the background of the Gezi insurrection. Since the early 2000s, certain insurrection movements targeting governments emerged in Turkey's neighboring regions. They were shaped within specific methods carried out by networks and organized groups operating under the appearance of civil society. In those judgments, it was noted that the same methods were applied during the Arab Spring. And in some countries, these methods laid the groundwork for developments that led to civil wars, while in others they resulted in bloody changes of power. The Gezi insurrection has been assessed by national courts as a manifestation of the violent rebellion movements we've described. The aim is to prevent the functioning of the democratically elected government and to overthrow it. Indeed, the Gezi insurrection was a process that had been prepared since 2011, organized through social media and implemented in a planned manner. The Gezi Park served merely as a pretext to achieve this objective. The insurrection must be assessed within this context and this background. In 2013, the situation had turned into widespread violence. For 4 months, a violent uprising took place, particularly in the heart of Istanbul and across the country, threatening the lives, the physical integrity, and the property of innocent people. In the course of the Gezi insurrection, 280 workplaces, 259 vehicles, 103 police vehicles, certain police stations and many public buildings were damaged. The Prime Minister's office was targeted. 12 political party premises and a significant amount of public infrastructure were destroyed. 8 civilians and 2 police officers lost their lives, and more than 9,000 people were injured. The figures clearly show that the events in question went far beyond the limits of peaceful protest that are considered normal in democratic society. Mr. President, esteemed members of the court, the detailed findings of national courts also demonstrate that the incidents constituted a process directed by certain individuals and organizations, particularly the Taksim Solidarity and Platform. These structures directed crowds and manipulated them through social media, and they facilitated the protests nationwide and the involvement of various terrorist organizations in the incidents. And the directing role is clearly visible in a press statement issued by these structures in a period when the acts of violence intensely took place. In the statement made the day after the Prime Minister's office was targeted, the following expressions were used: "We are united on the street, we will win on the street, we are united on the street, we saw our strength, we know we will win on the street." According to the findings of the national courts, the applicant occupied a central position in the Gezi insurrection. The applicant was regularly informed by the Taksim Solidarity officials about the course of the protests. His instructions were regularly sought as to how to respond to new developments. The applicant also played a key role in determining and shaping the narrative directed at the international public opinion regarding the Gezi insurrection. In the light of the concrete evidence available in the case file, it would not reflect the true nature of the incidents to characterize the applicant's role as civil society activity. The applicant disregards the comprehensive findings of the national courts and reduces a complex and violent process to a narrow and incomplete framework. For this reason, the present application must be examined in light of the established factual and legal framework and in accordance with the principle of subsidiarity. In conclusion, we are of the opinion that if the court examines the present application within the context assessed by national courts, it will arrive at a conclusion that is consistent with the reality of the incidents. Mr. President, I request that you give the floor to Professor Bozbahindir. Thank you very much for your comments. Professor, you have the floor.
Mr. President, distinguished judges of the court, democracy is inherently fragile, and for that reason it must be protected. States have not only the right, but also the duty to safeguard democratic order against serious threats, especially the threats threatening the life of a nation. Article 312 of the Turkish Penal Code reflects this legitimate objective, serving as one of the legal instruments through which the state protects democratic institutions and public order. Article 312 is a traditional state protection offense, requiring the existence of an attempt. It safeguards the very existence of the state and the institutional integrity of the executive as a constitutional organ embodying the will of the electorate. In this respect, holding especially the plotters of a violent insurrectionary movement accountable is essential to effectively safeguard citizens' lives, physical integrity, and property from large-scale violence. Indeed, where state authority is destroyed, citizens' parliamentary and electoral rights become illusory, and the result is the destruction of democratic society. Functionally equivalent provisions exist across Europe, including the offense of rebellion under Spanish Penal Code, Article 472, the German Hochverrat, Section 81, and the French, Article 412 et sec. 3, which criminalizes insurrectory movements and related offenses. These offenses are designed to act early, enabling state to prevent threats to the constitutional order before they materialize. Relatedly, Article 312 of the Turkish Penal Code, like its European counterparts, is a collective offense. With that I mean they should be treated differently from individual offenses, and the analysis we provide for such offenses, just the name, murder or robbery. This is a collective offense committed through the convergence of multiple acts and the involvement of an interaction of multiple actors, as in the present case. The offense is consummated at the stage of attempt. Article 312 of the Turkish Penal Code criminalizes attempts to abolish government, and importantly, any attempt to prevent, in whole or in part, from performing the government from its duties. This is an endangerment offense. Article 312 of the Turkish Penal Code applies once coercive acts aimed at overthrowing the government are set in motion. Completion of the objective is logically not required, because in such offenses, if you succeed in completing, probably there will be no judge to try such an offense. The initiation of execution thus suffices. Thus, the state resilience does not preclude criminal liability. In this regard, as Mr. Ali emphasized, the Gezi protests constitute an insurrectionary movement. At the height of the June 2013 disturbances, Taksim Solidarity, a principal actor in this case, described the country as a scene of fire, and presented the protest as a decisive force, asserting that the state's credibility was eroding and that this was only the beginning. These statements sought to legitimize violence and signal to both to the public and the authorities that attempts to undermine state authority had become sufficiently organized and were likely to continue. It is also of note that, as explained in detail in the Court of Cassation's judgment concerning the context and background to the Gezi, certain preparatory activities had been carried out since 2011, long before the violent insurrectionary movement. Indeed, in such offenses, what matters is a case-specific assessment, taking into account the political and social context at the time of the acts and the significance of the object targeted. Mr. President, honorable judges of the Grand Chamber, we now wanted to come to the one of the major bones of contention of this case, which is the proper test of legality. The applicant's approach contains a fundamental error regarding the scope of legality, as it completely disregards the general part of criminal code. The applicant claims that, I quote, there is no shred of evidence referred to by domestic cause which establishes that he resorted to use of force or violence. End of quotation. This is a mischaracterization of the factum probandum. The proposition underlying the applicant's approach can be summarized as, if no violent act he did commit, you must acquit. Nonetheless, the applicant was not convicted for committing violent acts personally, but as a co-perpetrator of the offense in conjunction with Article 37 of the Turkish Penal Code. The domestic courts convicted the applicant as a co-perpetrator alongside other co-accused for his involvement in the organization, planning, and leadership of the insurrectionary movement. Accordingly, his acts and role were assessed within the context of the collective act of insurgency, involving violence and coercion. I quote directly from the Court of Cassation's judgment, page 63. Indeed, classical doctrine on crimes against state has long distinguished between those who execute and those who direct. Since 1605 gunpowder plot, this has not changed. A co-perpetrator belonging to the leadership card is not required to have personally used violence. Accordingly, it is not necessary for co-perpetrators themselves to carry out acts of violence. At this moment, I want to refer to an important work Ingraham observed in his trailblazing study on this specific legal problem as follows, I quote, plots, rebellions, riots, espionage, sabotage are group phenomena and require the inspiration and direction of a few talented individuals who often work behind the scenes and do not participate in the execution of the plan. If the law were limited to apprehension and punishment of the people who actually engage in physical acts of violence, these leaders will escape punishment and will be free to plot again. End of quotation. These insightful observations fit like a glove with the circumstances of the present case. Indeed, the evidence before the domestic courts demonstrate that the applicant was a figure whom others turned for guidance, provided material and financial support, and continued these activities after the violent acts had begun. We also submit that a person who provides infrastructure, financing, and strategic direction to an insurrectionary movement and continues to do so after it has become violent cannot reasonably claim that his contribution bears no causal relationship to the violence and coercion on the ground. Crucially, the contribution of an individual co-perpetrator need not to be causal for each individual act. What matters is that the co-perpetrator's contributions taken as a whole, taken together, are causal to the commission of the offense. Against this background, the domestic courts identified inter alia a causal chain of 5 elements establishing the applicant's functional contribution as a co-perpetrator. First, operational framework. The Court of Cassation found that the applicant provided the operational framework by coordinating meetings with the co-accused persons at his own institution and business, including his restaurant. Second, financing and logistical support. The applicant financed protesters and provided protective equipment for the continuation of confrontation with security forces. Third, media and diplomatic coordination. The applicant coordinated with domestic and international media to portray the events as peaceful demonstrations and sought to procure an international embargo on crowd control equipment. Fourth, continuing strategic direction, Intercepted communication showed that the applicant was continuously consulted by leading participants on strategic decisions throughout the events. Fifth, the nexus with coercive effect. The domestic courts found that the terror organizations and mobs were instrumentalized during the events. In short, the applicant's role created the conditions in which sustained mass disruption, combined with violence, exerted coercive pressure on the government's functional capacity. The government thus submits that Article 312 and the relevant general provisions of the Turkish Penal Code fully satisfy the principle of nurum clement sine lege as enshrined in Article 7 of the Convention. The applicant, however, seeks to transform the court into an appellate court. The government respectfully invites the court to exercise particular caution in this regard. We emphasize that the court cannot itself assess the facts which have led a national court to adopt one decision rather than another. Otherwise, it would be acting as a court of first instance and would disregard the limits imposed on its role. Questions of evidence relate to the likelihood of conviction. Reviewing the evidence to determine whether the domestic courts correctly established the elements of Article 312 of the Convention will transform Article 7 from a guarantee of legality into a vehicle for re-evaluating evidence. Mr. President, members of the Grand Chamber, at this juncture, we wish to emphasize that the applicant's approach to evidence is also fundamentally misleading. The applicant isolates each act and portrays them as trivial. Yet when viewed collectively, these acts form part of the offense. A fundamental principle of criminal evidence assessment, not only in Turkey, is that all essential facts must be considered together. No individual item of evidence should be assessed in isolation. Its true probative value emerges only in the context of all other circumstances. This is particularly important, such as this case, in complex cases of collective conduct, where evidence spans networks, unfolds over time, reflects coordinated activity, admittedly very complex. The question is always what the totality of the conduct reveals when the acts are considered together. Indeed, the domestic courts in the present case did not convict the applicant, say, for distributing salted pastries. They convicted him because when the evidence was assessed as a whole, as the Court of Cassation's methodology requires, a coherent operational direction emerged. The pastry was distributed at coordination points during violent unrest. The meetings were planning sessions for escalation. The telephone calls were instructions to other co-perpetrators and intermediaries. The government wishes to underline that nothing in these submissions is intended to undermine the importance of the protection afforded by the Convention. No, we don't say that. Nonetheless, this case is a good example of why international courts should not go into the details of a national criminal procedure. Indeed, an international court which does not have the case files and evidence at hand is too far away to assess which measures might have been required at certain stage of the proceedings. In particular, and I think it's very important for the purposes of present case, the assumption that the applicant himself must have resorted to violence cannot serve as a basis for overturning a national finding. Importantly, assuming that an earlier finding of this court, I refer to 2019 and perhaps also the 2022 judgments, assuming that such judgments earlier findings of this court precludes any further action by the national authorities would in effect transfer the jus puniendi of the contracting party to this court, and result never intended by the drafters of the convention. In this connection, the government still wants to draw the Chamber's attention to the verifiable evidence relied upon by the domestic courts which established the applicant's role in the insurrection. The evidence includes intercepted communication with verified timestamps, physical surveillance, and documentary records, as set out in the Court of Cassation's judgment. The content of the communication has also been acknowledged by the applicant. The government presents this evidence in temporal sequence because when the individual acts are reconstructed in their chronological context, alongside the concurrent acts of violence, the pattern of operational control becomes explicit. Here are some crucial examples from the concrete judgment of the Court of Cassation and the Court of First Instance. On the 30th May 2013, the very day the first stone attacks occurred against police officers in Gezi Park, the intercepted communications record a conversation between the applicant and co-accused MO concerning the opening of a bank account, depositing of funds, and the procurement of supplies for protesters. This is a logistical coordination on the very first day of violence. On the 1st and 2nd June 2013, the violence escalated, targeting riot control vehicles in Sultan Gazi Police Station, Sancaktepe District Governorship, and police officers guarding the Prime Minister's office at Dolmabahce. On the 2nd of June, the intercepted communication showed that the applicant coordinating tables, chairs, sound system, and food for protesters. On 11th of June 2013, at the peak of violence, the applicant was intercepted speaking with OD, who said, "We need gas masks, even substandard ones do." The applicant provided guidance on their procurement. On the 10th, 20th, and 24th of June 2013, the applicant was intercepted discussing the imposition of an international embargo on the sale of tear gas to Turkey. It is a concrete act designed to weaken the state's capacity to restore public order. What else? On 13 June 2013, at the height of the violence, in order to de-escalate the situation on the ground, a referendum on the Gezi project was proposed. The applicant was consulted on this matter, and despite the referendum being a reasonable democratic solution, he insisted on opposing it. This underscores 2 points. First, the issue extended beyond the Gezi Park project itself. And second, the applicant was a decision maker who opposed any de-escalation of the insurrectionary movement by rejecting a clearly democratic solution. On 24th June 13, as participation waned, the applicant and HHG noted the resistant may lose momentum. And now they explored new ideas, such as spreading it to the Anatolia. Under the applicant's guidance, forum coordination structures were established, meetings organized, and his venues actively used. The Court of Cassation found that briefings and decisions were systematically reported to the applicant. In sum, the Court of Cassation found that the applicant exercised decisive influence over both Taksim Platform and Taksim Solidarity. Returning Article 18. Furthermore, the applicant's allegations under Article 18 and his broader request suffer from a hyperinflation, at times relying on a mischaracterization of both facts and law. For example, he contends that Article 18 should be applied in conjunction with Article 7, arguing that Article 7 is not an absolute right. This is incorrect. In 2024, this court said explicitly Article 18 cannot be applied in conjunction with Article 7.
Two minutes more.
Thank you, Mr. President. The whole structure of the Convention rests on the general assumption that public authorities act in good faith. As a founding member of the Council of Europe, the government fully endorses this principle. Yet the applicant's approach will reverse the burden of proof, exposing a state upholding its security to accusation of malafide action, clearly contrary to the Convention's letter and spirit. The burden of proof must therefore remain with the applicant, both de facto and de jure. Merabishvili broadened this high standard, but still maintained a high standard of proof. Maintaining a high standard of proof is good law. Where standard of proof any lower, the court will be compelled to find violations in every high-profile case. The investigation and criminal proceedings against the applicant, a leading figure in the country's most extensive recent insurrection, were necessary and lawful. To accept the contrary would hand a carte blanche to those claiming to defend human rights while seeking to overthrow the legitimate government. And regarding other allegations, the applicant has failed to demonstrate any concrete link between the alleged violations of fair trial rights and the outcome of the trial. I hope, the government hopes, that the court should withstand the applicant's persistent invitation to blur distinction between facts and law and to assume a role of court of first instance, an outcome directly contrary to the principle of subsidiarity enshrined in the Convention. The government, therefore, respectfully invites the court to conclude that no violation of the Convention has occurred. Thank you.
I thank you, and I now call Professor Leach.
Mr. President, Osman Kavala is a civil society activist and human rights defender. He's been long active in advocating for cultural rights of minorities and artistic freedoms and the values of democracy, peace and reconciliation. He is an innocent man who has been unlawfully and arbitrarily locked up in a Turkish prison for more than 8 years as a result of a flagrant abuse of the criminal justice system which has been instrumentalized in order to silence him. His case is unprecedented. Never before has a third case come before this court following 2 previous judgments, one of which found violations of Articles 18 and 5 and ordered Mr. Kavala's release, and the second, an infringement proceedings judgment finding a breach of Article 46. After setting out the context of this case, I will address the question of domestic remedies before explaining why Articles 5.4 and 5.1 have been breached. Professor Chawla will then address the court in relation to Articles 6 and 7, 10 and 11, 18 and 3. It has always been made crystal clear that this case concerns the ongoing and new violations of the Convention perpetrated since this court's 2019 judgment. It is emphatically not, as the government would have it, a case relating to the implementation of that judgment. However, in order to elucidate the ongoing and new violations, it's of course essential to reiterate what this court has already found concerning the same criminal proceedings instigated against Mr. Kavala in 2017, which led to his conviction and sentence to aggravated life imprisonment in 2022. The culmination of his first case before this court was the 2019 judgment finding violations of Articles 5.1, 5.4 and 18 and a direction to the government to secure his immediate release. As that did not happen, the Committee of Ministers invoked infringement proceedings, and as a result the Grand Chamber found in 2022 that Turkey had failed to meet its legal obligation under Article 46.1 to comply with the 2019 judgment because of its failure to release Mr. Kavala from detention. These judgments are critical because of their very clear findings about the criminal case against Mr. Kavala. He was charged with attempting to overthrow the government by force and violence under Article 312 of the Criminal Code and attempting to overthrow the constitutional order through force and violence under 309. However, having carefully considered all the documents and evidence relied on by the authorities, this court found that there was not even sufficient evidence to establish a reasonable suspicion of his commission of any of these offences. Not only that, but the measures taken against him were based on facts that could not reasonably be considered as behaviour criminalised under domestic law, and were essentially related to his exercise of convention rights, completely lawful acts, as the court underlined, the ordinary legitimate activities on the part of a human rights defender. Therefore, Article 5.1 was violated because of a lack of reasonable suspicion that Mr. Kavala had committed any offence. The court also found a violation of Article 18 because the criminal proceedings pursued an ulterior purpose, reducing Mr. Kavala to silence. The court noted the 4 years of delay in bringing the case after the events in question, which was totally unexplained, and found it significant that the charges were laid shortly after 2 speeches made by President Erdogan, who alleged that Mr. Kavala financed terrorists in the context of the Gezi events. The Grand Chamber clearly held that the 2019 judgment applied to the totality of the charges against Mr. Kavala. As for the ruse of charging him with different crimes to continuously keep him in detention, the Grand Chamber held that this constituted a mere reclassification of the same facts, which amounts to the circumvention of the law. Indeed, over the last 8 years, the underlying allegations and so-called evidence have remained essentially the same, in spite of what the government tries to argue. The court found that it was clear that his conviction was based on facts, quote, which the court had scrutinised with particular care in its initial judgment on account of the clear absence of reasonable suspicion, unquote, and that the facts listed in the 28 September 2020 Bill of Indictment were essentially identical to those already examined by the court. The Grand Chamber concluded that the findings of a violation of Articles 18 and 5.1 vitiated any action resulting from the charges relating to the Gezi events and the attempted coup. These findings are critical to this case because they relate to the same arbitrary criminal process which has been pursued to this day for ulterior political purposes. Nevertheless, the government continues to push the conspiratorial narrative to justify why Mr. Kavala was convicted and sentenced to aggravated life imprisonment. Their narrative alleges that the Gezi Park protests amounted to an insurrection and that they were planned by George Soros and other external actors and directed and financed by Mr. Kavala in order to overthrow the government by force and violence. But this narrative is simply not justified by any objective evidence, as this court has already found. The wider rule of law and human rights context in Turkey is, of course, an essential element of this case, which is made abundantly clear by the 17 third-party interveners, including the Commission for Human Rights, 4 Turkish-based organisations, and 11 other international bodies, among them associations of judges and lawyers. These interventions show that government critics, including opposition politicians and journalists, face a combination of legal, administrative and judicial pressure and criminalisation. This is also the case for human rights defenders. The interventions highlight the degradation of the independence and impartiality of the judiciary, especially in politically sensitive cases, aided by the weakening or removal of key legal and constitutional safeguards, as well as governmental control of the Council of Judges and Prosecutors, and direct political pressure publicly exerted by President Erdogan and other ministers, which has led to judges and prosecutors close to the government being given key roles. They also trace the non-implementation of judgments of the Constitutional Court by the lower courts and the Court of Cassation, including for 2 of the defendants in the Gezi proceedings, Can Atalay and Tayfun Karaman, as well as the non-implementation of European Court judgments, egged on by public utterances from government ministers reflecting outright resistance. The interventions also reveal patterns of prosecutorial practice in producing overly long indictments which lack sound legal analysis, target legitimate democratic activity protected under the Convention, and which are insufficient to establish the crime in question. We also see the initiation of multiple overlapping criminal charges based on identical or similar facts and legal grounds, criminal proceedings initiated on the basis of overly broad interpretations of criminal offences, and courts issuing release orders that are not executed because new detention orders are issued at the same time. Mr. President, each of these issues arise in Mr. Kavala's case too. I turn now to the question of domestic remedies. Since October 2017 to date, Mr. Kavala has pursued numerous domestic court applications, including more than 50 appeals against his ongoing detention, appeals against his conviction, and 4 petitions to the Constitutional Court, 2 of which remain pending, although they were lodged in June 2022 and October 2023, respectively. He also invoked a series of extraordinary legal remedies under the Criminal Procedure Code in 2024. All of this has been to no avail whatsoever. It is beyond any doubt that he has exhausted domestic remedies, as he's done everything he can reasonably do to apply to the Turkish courts to secure his release from unlawful detention. The domestic courts have proved themselves unable to provide an effective remedy, as they have repeatedly failed to consider either of this court's judgments. This is true of the lower instance courts, the appeal court, the Court of Cassation, and the Constitutional Court. And the Constitutional Court cannot be considered an effective domestic remedy in this case, firstly, because its December 2020 judgment failed to provide Mr. Kavala with a remedy. Secondly, because of the inexplicable excessive delays in adjudicating on his cases. Thirdly, because of the frequent ministerial public statements criticising its handling of cases concerning the Gezi Park convictions. And fourthly, because its decisions in these cases have been openly rejected by the lower courts and the Court of Cassation on 3 occasions, twice in the Can Atalay case, once in the case of Tayfun Karaman. The Court of Cassation even filed a complaint to the prosecutor against 9 Constitutional Court judges for supposedly violating the Constitution in the Can Atalay case. The pattern is very clear. It's true of other cases too, that under overt political pressure from the President and ministers, it unquestionably does not provide an effective remedy in the light of the violation of Article 18 in this case. The government argues that this case is inadmissible because Mr. Kavala should still have waited for the Constitutional Court to rule on his 2 outstanding applications before coming to Strasbourg. It places substantial reliance on the 2013 admissibility decision in Uzun in Turkey, a case about a boundary dispute, in which the court assessed their newly introduced individual system of complaint before the Constitutional Court, finding that in principle it should be invoked by applicants. However, the circumstances of this case are fundamentally different to that case, which predated the 2018 constitutional reforms. For the reasons I've already outlined, the Constitutional Court does not provide an effective remedy in this particular case. Mr. President, I turn now to Article 5. Article 5.1 was violated from 10th December 2019 to the date of confirmation of Mr. Kavala's conviction on 28 September 2023 as a result of his continuing arbitrary deprivation of liberty, in line with this court's finding in 2019. In spite of what the government still tries to maintain, nothing of substance changed. His detention was based on the same facts which had been assessed by this court in 2019, which found there was not even sufficient evidence to justify his arrest. Although the authorities changed the nature of the charges, no new facts or evidence of any substance were adduced by the authorities. The Grand Chamber in 2022 had to carefully assess this very point. It found that the limited new evidence put forward by the prosecutor in February 2020 in relation to the charges under 309, quote, did not contain any new fact related to the constituent elements of the alleged offence, unquote. As regards the charge of espionage under Article 328, it found that neither the decisions on Mr Kavala's detention nor the bill of indictment contained any substantially new facts relating to the constituent elements of that offence. It concluded that, quote, as during Mr Kavala's initial detention, the investigating authorities once again referred to numerous acts which had been carried out entirely lawfully in order to justify his continued pre-trial detention, unquote. This had also been the conclusion of the dissenting judges in the Constitutional Court in December 2020. This breach of Mr Kavala's right to liberty persisted after his conviction. A conviction cannot be the result of a flagrant denial of justice, as per Ilashku and Navalny number 4. Accordingly, his arbitrary detention post-conviction cannot satisfy Article 5.1a. Mr Kavala's rights under Article 5.4 have also been breached because of the failure to provide a sufficiently swift review of the lawfulness of his detention. He petitioned the Constitutional Court on 9th June 2022, and his conviction became final on 28 September 2023, a period of more than 15 months. Article 5.4 is applicable to the period after the first instance conviction, in accordance with Stoltenberg in Germany and Yilmaz Aydemir and Turkey, because the Turkish domestic law does not distinguish between the pre- and post-conviction periods in relation to procedural guarantees in the context of challenges brought against detention. In line with this court's case law, 15 months is too long to meet the court's very strict standards where individual liberty is at stake. Such a period is inexplicable and unjustifiable, especially in this case in the light of 2 prior European Court judgments. In fact, the court's case law is clear that as an exception to the incorporation doctrine, Article 5.4 applies where new questions concerning the legality of the detention arise even after the final conviction, cases such as Todorov and Etude against Luxembourg. And here this applies because of the findings of the Grand Chamber in 2022, and therefore the time period for Article 5.4 extends to today. That's 4 years and 9 months. Thank you, Mr. President. I now give the floor to Professor Challa.
Thank you, and I now call Professor Chali.
Dear Mr. President, dear members of the court, Mr. Kavala has been denied a fair trial in serious breach of Article 6 of the Convention. The government has not provided any evidence to show how the domestic courts compensated for the deficiencies already identified by this court under its review of Article 5 and 18 to respect Mr. Kavala's right to fair trial. On the contrary, there is abundance of evidence showing that it was a manifestly unfair trial that led to Mr. Kavala's conviction and sentencing to aggravated life imprisonment. Let me outline 5 reasons as to why there has been a violation of Article 6. First is the complete disregard for the 2 European Court judgments by the domestic courts. The findings of the European Court's judgments were not mentioned, let alone considered in the decisions convicting Mr. Kavala. Yet extensive legal engagement with the European Court's judgments was the only way for Mr. Kavala's trial to be fair, as this court held in Mamadov No. 2 and Ismailova No. 4, the present case concerns the same criminal proceedings against the applicant involving the same charges stemming from the same events. This resulted in an unfair examination of the criminal charges against the applicant and also deprived him from his right to a reasoned court judgment. Second, Mr. Kavala's right to receive a fair trial from an independent and impartial court was violated. The 3 judges who delivered an acquittal judgment in Mr. Kavala's case on 18 February 2020 were subject to disciplinary investigations that resulted in a decision of misconduct. Subsequently, a former AKP candidate was appointed as a judge in this case. The disciplinary punishment of 3 judges who released and acquitted Mr. Kavala clearly constitutes a chilling effect on all judges who subsequently tried him. This is due to the clear political influence and control over the Council of Judges and Prosecutors. The Council is responsible for all judicial appointments, including appointments to the Court of Cassation, the career progression of judges, the geographical location of judges, and their disciplinary investigation. And this Council has 13 members. The Minister of Justice presides over this Council, and their deputy is an ex officio member. The Minister of Justice is appointed by the President. In addition, the President directly elects 4 other members of this Council. And the remaining 7 members are elected by a qualified majority of the Parliament, which de facto means appointment by the Justice and Development Party, whose leader is the President, and its alliance partner. The Venice Commission, in its 2024 report, refers to a climate of fear and submission amongst judges in Turkey due to the political control over the Council of Judges and Prosecutors. The government states that the appointment of a former Member of Parliament candidate, in this case a Justice and Development Party candidate, as a judge in this case is a normal practice. However, according to the well-established case law of this court, a judge's political affiliations having links to the case at issue constitutes an objective fear of lack of impartiality. And given that the President and the leader of the Justice and Development Party is a civil party to the proceedings in this this test is clearly met. Third, Mr. Kavala's right to equality of arms in this trial is violated. He was not able to access the digital audio files, which included transcripts of his telephone conversations, indeed the bulk of evidence that is presented to you, verify their accuracy, or examine their evidentiary value in accordance with the Criminal Code of Procedure. In addition, he was denied the right to have key witnesses heard in this case. And fourth, the presumption of innocence of Mr. Kavala was violated throughout this trial by prejudicial statements by the highest executive officials. Even a television series funded by the taxpayers' money was aired on state television, which clearly suggested that Mr. Kavala was guilty. And fifth, a period of almost 6 years which breached his right to a fair hearing within a reasonable time. And this length of time was marred with procedural irregularities which cannot be legally explained. Notably, the Third Regional Court of Appeal quashed Mr. Kavala's acquittal by second-guessing the outcome of a case not yet decided by the Court of Cassation. This led Mr. Kavala's trial to be irregularly moved from one court, the court that acquitted him, to another court, and then it being joined by the trial of a group of football fans for the unrest during the Gezi Park protests, a large group of individuals he has never met in his life. His case was subsequently separated from the trial of the football fans, causing significant delays in the proceedings, again, not possible to explain, in contravention of what was at stake for the applicant as per Kudla versus Poland, his immediate release from unlawful detention. Dear Mr. President, Mr. Kavala's conviction for the crime of attempting to overthrow the government by use of force and violence or preventing it from fulfilling its duties under Article 312 of the Criminal Code is a clear violation of the foreseeability test under Article 7. Now, the material element of this crime requires evidence that Mr. Kavala is responsible for the use of force and violence which is capable of overthrowing the government. This material element is manifestly not met in this case for two clear reasons. First, there's absolutely no evidence presented in the domestic court judgments that links Mr. Kavala to any use of force and violence during the Gezi Park protests by any group, let alone evidence that Mr. Kavala directed or financed any group that used force and/or violence. Second, there is no evidence that the Gezi Park protests could be characterized as use of force and violence in an attempt to overthrow the government. The domestic courts provide two specific reasons for this characterization. First is the clashes between protesters and the police in front of the then Prime Minister's office in Beşiktaş, Istanbul, around 2nd and 3rd of June 2013. And second is the alleged involvement of members of terrorist organizations in the protests more generally. With regard to the first allegation, the Court of Cassation judgment states that the protesters in front of the then Prime Minister's office in Beşiktaş wanted to give the impression that the government had fallen. This would not have been rationally possible, not least because the seat of the Turkish government is in the capital, Ankara, and not in Istanbul. Significantly, there is no evidence whatsoever to show that the government was not able to go about its daily business throughout the Gezi Park events of May and June 2013. In addition, the government held meetings with civil society representatives and organizations during these protests, including meetings that the then Prime Minister Erdogan held with groups of protesters on the 12th and the 14th of June 2013. And even more significantly, the football fans case, the case which Kavala's trial was irregularly joined and separated again, in this case, which were specifically about the incidents that happened in front of the then Prime Minister's office in Beşiktaş, this trial has concluded on the 29th of December 2025, with all of the football fans being acquitted under Article 312. Now, with regard to the alleged involvement of terrorist organizations in the protests, there has never been any public investigation linked to the Gezi Park protests that looked into any incident of use of force and violence by any of the alleged terrorist groups alleged to be involved in these protests. In addition, no one has ever been convicted as a member of any terrorist organization under Article 312 in relation to these protests. Now, I must underline once again that Mr. Kavala's conviction judgment provides no link between any alleged terrorist organization, named or otherwise, and Mr. Kavala. The mental element of Article 312 requires evidence to show that Mr. Kavala intended to overthrow the government by use of force and violence. However, the totality of the material provided in the domestic court judgments constitutes one photo of Mr. Kavala during the Gezi Park protests, telephone conversations that he had discussing the need to organize events to talk about the protests and the disproportionate use of force by the police, discussions about sending letters to the European Parliament, to the Council of Europe, and European states, members of the Council of Europe, concerning human rights violations during the Gezi Park events. And for clarity, this European Court has already reviewed all this material which constitutes the alleged material and mental aspects of the crime. Now, this material shows that Mr. Kavala, as a human rights defender, was critical of the government's way of handling Gezi Park protests, and he was concerned with the excessive use of tear gas, which caused serious injury and death during these protests. It also shows that peaceful and lawful activities of a human rights defender, such as raising human rights concerns before European institutions, were treated as constituting the mental element to overthrow the government with force and violence. It is worth emphasizing that when Article 312 was drafted, the term use of force and violence were added precisely to exclude freedom of expression and association from the scope of this crime. Now, the government submits that the application of Article 312 in this case is compatible with the previous case law of the Court of Cassation. Now, the case law referred in their submissions concern individuals who were members of the armed forces or individuals who were also charged with either establishing an armed terrorist group or being a member of a terrorist organization. So the factual basis of the Court of Cassation case law references that are presented to you concern people who have access to weapons and troops, and therefore bears no resemblance to the facts of this case. Dear President, the conviction of Mr. Kavala has gravely violated his rights to freedom of expression and association. At the heart of the Article 10 and 11 violations in this case is the criminalization of the exercise of Mr. Kavala's rights. This is an absolutely arbitrary restriction of his rights, is not prescribed by law, and utterly disproportionate. Dear members of the Court, violation of Article 18 constitutes a distinct and fundamental aspect of this case. Without any doubt, Article 18 applies to Articles 6, 10, and 11, but Article 18 also applies to Article 7 in this case. There was no intent on the side of the drafters of the Convention to limit the application of Article 18 to any of the rights provided for by the Convention. Rather, the travaux evidence is overwhelming that Article 18 was introduced as an additional safeguard against the abuse of power by states, regardless of the substantive rights that may provide the context of such abuse. If there are violations of Article 18 with Articles 5 and 6 in politically motivated prosecutions and trials, then a violation of Article 18 and 7 should not be precluded. In our written submissions, we provided the Court with the following evidence. 1. Insistence on exclusively relying on the same irrelevant and insufficient evidence that this Court has already reviewed. 2. The lack of succinct statement of facts in the domestic court judgments, which this Court has already identified. 3. Manifest procedural irregularities under Article 6. 4. The exercise of Convention rights as the basis for conviction to aggravated life imprisonment. 5. The profoundly arbitrary sentencing of Mr. Kavala to the heaviest possible criminal sentence. 6. Correlations between the prejudicial statements of the highest executive officials about Mr. Kavala and the very content of the domestic court judgments. And 7. The absolute non-engagement and non-compliance with the findings of these court's judgments in the totality of the trial. Dear President, Article 3 has been violated in this case. The de minimis threshold of Article 3 has clearly been reached in this case due to the extremely long and unlawful deprivation of liberty of an innocent man. In addition, his wait to be released and to be with his family has been in defiance of 2 judgments of this court. This has caused prolonged anguish and uncertainty to a human being who has a legitimate expectation to be free.
2 minutes more.
This court held in Babar Ahmed and others versus the United Kingdom that a grossly disproportionate sentence could amount to ill treatment contrary to Article 3 at the moment of its imposition. In this exceptional case, sentencing an innocent man to aggravated life imprisonment meets the strict test of gross disproportionality. In addition, it has already been established by this course, inter alia in the case of Kayıt versus Türkiye, that the lack of any possibility of conditional release from an aggravated life sentence at the moment of its imposition violates Article 3. Dear judges of the Grand Chamber, dear Mr. President, Mr. Kavala, an innocent man and a human rights defender, has been incarcerated for 8 years, 5 months, and counting. For the last 3 of these years, this has been in isolation. This unprecedented situation requires the application of Article 46 in this case. Accordingly, we request that the court requires under Article 46 that the national authorities immediately releases Mr. Kavala from detention and formally acquit him and allows him to continue his life free from any future risk of arbitrary deprivation of liberty or any violations of his convention rights. We respectfully request that the Grand Chamber to deliver a judgment as soon as reasonably practicable.
I thank you, and I now call Mr. O'Flaherty, Commissioner for Human Rights.
Thank you, Mr. President, distinguished members of the Court. This case, of course, concerns the rights of Mr. Kavala as an individual. At the same time, it points to the ongoing structural challenges facing human rights defenders in Turkey. I address the Court to share insight from my own work in a manner which I hope will further inform you about these issues. My intervention also touches on the enforcement of judgments of this Court. The present case concerns the continued detention of Mr. Kavala and the criminal proceedings which resulted in his conviction to aggravated life imprisonment after this Court issued 2 judgments mandating his release. The non-execution of those judgments is at the origin of the present case. Since taking up my mandate, I have engaged with the Turkish authorities and raised with them on more than one occasion the non-implementation of the judgments. In November 2024, during my first visit to Turkey, I visited Mr. Kavala in prison. I was impressed by his integrity, his resilience, and his commitment to the cause of human rights. In December 2025, I again visited the country, and during that visit, I engaged with the authorities, with legal experts, and with civil society organizations. In Kavala versus Turkey, this Court examined the proceedings against Mr. Kavala in light of his activities as a human rights defender. You established beyond reasonable doubt that the measures complained of pursued the ulterior purpose of reducing Mr. Kavala to silence. Further, in view of the charges that were brought against him, you considered that the contested measures were likely to have a dissuasive effect on the work of human rights defenders. The non-execution of the general measures required in the Kavala case is indeed indicative of the situation as I observed it as recently as 2025. During my visit, my interlocutors reported a continuation of pressure on civil society, human rights defenders, lawyers, journalists, and opposition politicians. They drew my attention to disproportionate restrictions to freedom of expression, peaceful assembly and association, the continued misuse of criminal and anti-terrorism provisions, and issues with regard to the independence and the impartiality of the judiciary. I am concerned that criminal law and anti-terrorism provisions continue to be broadly interpreted and applied to actions that should be considered as legitimate democratic activity. This includes, for example, non-violent acts, critical expression, association, human rights advocacy. Furthermore, reports indicate that domestic courts tend to initiate criminal proceedings without sufficient or adequate reasoning and without a clear link between any alleged conduct and violence, incitement to violence, or other elements required to justify criminal sanctions. I've also received reports of repeated restrictions on demonstrations and assemblies, disproportionately impacting certain groups, with police using unnecessary force to disperse peaceful protest. I have been informed that journalists, opposition politicians, lawyers, and ordinary citizens have faced criminal investigation simply for voicing dissent. In addition, bar associations and legal professionals face pressure and criminal prosecution for their work. Associations working on human rights suffer from legal, administrative, and judicial constraints, including arbitrary audits and criminal cases in which advocacy is treated as evidence of wrongdoing. These reports indicate persistent problems regarding the rights to freedom of expression, association, peaceful assembly, and they echo problems identified in judgments of this Court that are still pending execution before the Committee of Ministers, indeed for periods ranging from 9 to 20 years. The failure of the authorities to resolve these issues lies behind repeated human rights violations today. Allow me to turn to the administration of justice and the protection of human rights within the justice system. This Court assessed aspects of the functioning of the justice system in the Kavala versus Turkey case. During my recent visit, I was informed about continuing issues concerning the independence and impartiality of the judiciary, the right to a fair trial, and regarding the operation of the Turkish Constitutional Court. Concerning the independence and impartiality of the judiciary and judges, I note that problems have been exacerbated by several constitutional and legislative amendments that alter the composition and selection procedure of the Council of Judges and Prosecutors. These run counter to recommendations of international human rights and expert bodies, including 2 opinions of the Venice Commission. And this court indeed has referred to such matters in the cases of Selahattin Demirtas and Yüksedag Senoglu. Turning to issues relating to the right to a fair trial, multiple practices raise concern related to legal certainty and foreseeability. These include overly long indictments, shortcomings regarding legal analysis and the quality of evidence, the use of secret witnesses, and the initiation of multiple overlapping criminal cases based on identical or similar facts and legal grounds. Equally, legal process is threatened by the non-execution of release orders with new and simultaneously issued arrest and detention orders. I have also been informed that the principle of equality of arms is undermined inasmuch as lawyers are restricted in the exercise of their professional activities. Finally, I turn to considerations regarding the Turkish Constitutional Court. I note that Mr. Kavala has 2 applications pending before the court, one since 2022 and another since 2023. These respectively concern his detention and conviction in the Gezi Park case and the upholding by the Court of Cassation of his conviction. The effectiveness of the individual application mechanism before the Turkish Constitutional Court constitutes a central judicial safeguard. But in this regard, I would wish to raise 2 matters. First, issues have been brought to my attention by my interlocutors about the Constitutional Court's slowness in reviewing individual complaints. Despite the Committee of Ministers' call to strengthen the Constitutional Court's priority criteria, no measures have been taken or are envisaged. As a result, cases of deprivation of liberty are not addressed with the speediness required under criteria of this court. Second, there have been several recent instances where Constitutional Court judgments have not been implemented by the lower courts. I draw the court's attention in particular to the cases of Kan Atalay and Tayfun Karaman, co-defendants of the applicant in the Gezi Park case. In conclusion, President, honourable members, I believe that the contemporary situation for human rights defenders and civil society in Turkey, together with issues of the maladministration of justice, are highly relevant in the present case, and I encourage the court to give them due consideration. I thank you.
I thank you for your submissions. And I now invite the judges of the Grand Chamber wishing to do so to put their questions to the parties. And Judge Barton, Vice President of the Court, just wants to ask some questions.
Thank you very much, Mr. President. I have one question to the respondent government and one question to the representatives of the applicant, and I have one question for both parties joint. D'abord, j'ai une question principalement.
I have a question for the government mainly, but then the applicant's representative are obviously free to comment and answer if they so wish. My question is the following. It's about domestic remedies and their exhaustion, and about the fact that the applicant still has 2 proceedings pending before the Constitutional Court. My question concerns the priority policy of the Constitutional Court in cases pending before it, and where the applicant is deprived of his liberty, either in pretrial detention or following a conviction. Are there statistics, for instance, about the length and delays is there a specific profile of cases that tend to take more time?
Question for the representatives of the applicant, but of course the representatives of the government may also comment if they so wish. Both in the written and now today in the oral pleadings, the representatives of the applicant argue, albeit rather succinctly, that there has been a violation of Article 5, paragraph 1a, for the period after Mr. Kavala's conviction in 2022, because the criminal proceedings against him represented a flagrant denial of justice. May I kindly ask you to expand on that concept within the present context, both as to its rationale and as a matter of convention law in respect of specifically Article 5, paragraph 1a, and secondly, as to the elements that in your view would allow this court to conclude that there was in the current case such a flagrant denial of justice. This takes me to my third question, which goes to both parties. It relates to the complaint under Article 3 of the Convention, and in particular the question whether the conviction to an aggravated life sentence is a violation of Article 3. And my question is related again to admissibility and non-exhaustion and the existence or not of an effective remedy in this respect. This element is a bit underdeveloped, one might say, in the written submissions by the parties and has not been touched upon at all in the oral pleadings. This needs a bit of an explanation from my side. We have before us, I think, a development when it comes to this question, at least in three stages. First, we have the judgment from this court in 2015, Kayıt versus Turkey, where the court said that there was no remedy available in Turkish law against such a sentence. And it needs to be mentioned that this case referred to facts prior to the establishment of the individual complaint mechanism before the Constitutional Court. Then, 4 or 5 years later, 2018, December, this court, in a chamber formation in the case of Tekin and Baysal contre Turkey, which was mentioned in the written pleadings by the government, this court said that the individual complaint mechanism before the Constitutional Court is, in fact, to be considered an effective remedy in the case of an aggravated life sentence. This has been followed up in subsequent practice from committees and also at the level of single-judge decisions. Then, and this is the third stage, which we possibly find ourselves now, after this, then the court has started to receive new complaints from applicants in Turkey, where the applicants actually went to the Constitutional Court, applying a remedy that this court found to be effective. Actually, the applicant in one of the committee cases just referred to is one of the 4 cases we already communicated. And what we can see from this is, and now I'm getting closer to my question, what we can see from this is a clear pattern in the case law of the Constitutional Court, namely that these applicants before the Constitutional Court have all been declared inadmissible, without any particular clear reasoning, which is often the case when you declare a case inadmissible. But there is no examples before the Constitutional Court that it has actually accepted such a complaint, and we have so far, and this is really something I need to have confirmed from the parties, we have so far, to my knowledge, no ruling from the Constitutional Court in respect of this matter. And I ask both parties to, in light of this, to reflect upon and explain and express their view on whether there is still, in light of this, an effective remedy before the Constitutional Court, taking also into account the apparent ongoing execution before the Committee of Ministers in respect of previous judgment where this court has found violations of Article 3 in similar cases. Thank you so much.
Thank you. Is there another question? Judge Yüksel.
Thank you, Mr. President. I have one factual question for the applicant. Following the court's chamber judgment in 2019, the applicant was detained on new charges in 2020 and challenged the lawfulness of this new detention order before the Constitutional Court, where that court decided on December 2020 that his rights under Article 5 of the Convention had not been violated, as you also mentioned in your pleadings. We can see that the applicant did not lodge a new application with our court as regards that judgment of the Constitutional Court. So I would like to ask whether there was any specific reason for not lodging an application before our court following that Constitutional Court judgment. Thank you.
Thank you. Judge Cooks.
I would have one question to applicant and also one question to government. To the applicant as regards representatives, as regards Article 5. The government argued that the court has already decided on this freedom of liberty issue on the application of previous judgment, and this is an issue of execution by the Committee of Ministers. You framed it as an ongoing violation. Therefore, my question is whether you would argue that in any case where the judgment is not implemented, the court should have a policy to look at it, or whether there are any special arguments as regards this case. As regards government, it's in light of Article 6. Basically, the applicants about independence of the national court. The government applicants mentioned that 3 judges who acquitted the applicant have afterwards been disciplinary sanctioned, and that there are also, if I understood correctly, criminal proceedings against the Constitutional Court judges. I would like to ask you first whether you can comment a little bit of that about these 3 judges, whether there were any disciplinary proceedings against them before, and also about this issue of any proceedings brought or as regards Constitutional Court judges. Thank you.
Thank you. Judge Chantoria, Section President.
Thank you, Mr. President. I have one question to the government, following the questions asked by Vice President Portson. In its judgment of December 2019, the case Kavala versus Turkey, the court held that the total duration of the Constitutional Court's review of the lawfulness of the applicant's pretrial detention, namely 1 year, 5 months, and 29 days, could not be considered compatible with the speediness requirements of Article 5, Paragraph 4. The same conclusion was confirmed in the Grand Chamber infringement judgment in July 2022. As already mentioned here, the applicant lodged an individual application with the Constitutional Court in June 2022 in order to challenge his detention, and these proceedings are pending for 3 years and 8 months now. Second application was lodged in October 2023, and that application has been pending for more than 2 years and 4 months. My question is, have there been particular reasons justifying such a long duration in dealing with the applicant's detention, which is covered by Article 5 of the Convention, and having known that there are 2 judgments of this court? Thank you very much.
Thank you. Judge Mercer.
Thank you. First of all, the question for the government, following on from Judge Bardson's question. You argue in paragraph 17 of your submissions on the basis of an average length of proceedings before the Constitutional Court of about 3 years, roughly. But would you agree, as argued by the applicant in paragraph 88, that in Turkish law, a person is treated as being on remand until a conviction becomes final, so that the relevant length of the Constitutional Court proceedings of 9th of June 2022 is that applicable to proceedings regarding pretrial detention and not the general Constitutional Court proceedings? And as a supplement to that, how long on average do you say that proceedings before the Constitutional Court challenging pre-trial detention should take? And secondly, I have a question for the applicant. You will have seen the figures in paragraph 17 of the government submissions for the average duration of the Constitutional Court proceedings of 3 years. What precise procedural steps do you say should normally have occurred by now before the Constitutional Court in the 24th of October 2023 application? Thank you.
Thank you. If there's no other question, the court we will now withdraw for 25 minutes, following which the parties will be able to submit brief observations in reply to the other submission, and also to reply to questions from the judges. So. The hearing is resumed. I draw your attention to the fact that judges will have the possibility, after hearing the answers to their questions, to ask for clarifications concerning these answers, without, however, asking any new questions. We start by calling Mr. Ehring or Mr. Boz Bayendir from the government, respondent government. Please, the floor is yours for your reply to the other parties' submissions and your answers to the judges' questions.
Thank you, Mr. President. Initially, I would like to reiterate our objections regarding the admissibility in this case, which was touched by also the judges, especially regarding Article 5. And there were also some questions asking regarding some statistics. And in order to be concrete and to provide the court a full-fledged information, we request kindly from yourselves to present written answers to some of the questions at least. Now I first would like to provide an overall response to what has been said by the applicant, and then I will move to the questions posed by judges, if I may, respectively. With all my respect, I want to draw your attention to one particular fact, the elephant in the room, if you like, the 2019 judgment. It's not easy for a government agent or counsel to criticize a court before its presence, and likewise in human relations, isn't it? So what I can say is, again, with all my respect to the court's judgments and the governments as well, paragraph 146 of the 2019 judgment, I just quote, the applicant charged by the prosecutor's office are legal activities, isolated acts which at first sight are unrelated to each other, or activities which were clearly related to the exercise of a conventional right. This is actually what the applicant has been alleging since then. And this is very interesting because this judgment has become, as it were, a petitio principii argument, a circular argument. When they appear before, the applicant appeared before the Turkish courts, hey, Turkish courts, I have a judgment secured from a European court and you cannot try me. That, put bluntly, that's the essence of his defense. So I hope in the light of our written observations and the final outcome of the proceedings, by the way, 2013 was not an easy year, and the ensuing years for Turkey was not easy either, including a coup d'etat attempt. You have several cases now arriving at the base of Strasbourg. So we, with all respect, the nature of the offenses, historical, political, and social context should be taken into due consideration by any court of law. So the final judgment, the Court of Cassation judgment, provides a reasoned judgment again, contrary to the allegations of the applicant. I don't say that, I don't claim that that the criminal justice system is a Fordist assembly line, that we perfectly, neatly, ornate, and everything done perfectly. My argument is that ascribing in such an existential crisis to a government something beyond that, Article 18 allegations, I think was a bit premature. So, with all, again, my respect, returning to 2019 judgment, when it applied to the government's case, the court adopted a piecemeal approach to the evidence. In my oral observations, I said another approach should be taken, overall assessment approach, Gesamtbetrachtung. But when I come to the Article 18, your standard of proof regarding Article 18, paragraph 232, the court says, reducing the applicant to silence, the work of human rights defenders. Two arguments. But there you apply the standard all the conditions taken as a whole, or taking analyzed collectively. So this is why we are here again in 2026. And one more further remark. Pre-trial detention or investigation stage in general in continental Europe suffers from an imbalance. We adopted système mixte from the French in the 19th century towards the end of Ottoman Empire, and later on during the Republic we adopted the Strafprozessordnung. And the essence of this système mixte is keeping some inquisitorial elements intact during the investigation stage. And the full-fledged trial is the essence of the matter, full hearing, principle of immediacy, oral hearing, etc. So, in such a complex and problematic case, I would say, passing judgments at that level of demanding judgments would at least counterproductive. Now I come to the Article 5. Post-conviction detention is obviously not a violation of Article 5. The court reiterates that a person convicted at first instance cannot be regarded as being detained for the purpose of bringing him before the competent legal authority on reasonable suspicion of having committed an offense. As to the conviction judgment rendered on Article 25th April 2020 by the Istanbul 13 Asise Court under Article 312 of the Criminal Code, the applicant's deprivation of liberty falls to be examined under Article 5(1)(a). The applicant did not bring to the court within the prescribed period the complaints under Article 5 regarding detention pursuant to Article 309 and 328 of the Turkish Penal Code following the court's violation decision dated 10th of December 2019. Accordingly, the applicant's Article 5 complaints concerning the pre-conviction detention should be deemed inadmissible because there were two proceedings 2019 judgment, 2029 judgment, you have already dealt with this case, and it will be an idem if you do so again in this case. So, in our opinion, that the present case, the applicant's detention under Article 5A satisfies all the conditions established in the court's jurisprudence. The issue of whether a period of detention is reasonable cannot be assessed in abstracto. Whether it is reasonable for an accused to remain in detention must be assessed in each case according to its special features. Continued detention can be justified in a given case only if there are specific indications of a genuine requirement of public interest which, notwithstanding presumption of innocence, outweighs the rule of respect for individual liberty. Now, Article 6. When the court deals with Article 6 of this case, I should reiterate, prior findings on detention do not automatically determine the fairness of analysis of the subsequent criminal proceedings. Fairness must be assessed as a whole. The obligation to examine in particular care the acts and evidence giving rise to proceedings should not be understood as an obligation to disregard evidence in the case file or to acquit the accused person. In the criminal proceedings, the applicant and his lawyers had access to all pieces of evidence. By the way, they have brought an argument before the court just today regarding digital evidence. They did not brought that before the court. We also reject their argument in that regard. The requirements of the principles of equality of arms and adversarial proceedings were complied. But again, context matters. I want to draw court's attention to an earlier, much earlier case of this court regarding RAF cases in Germany. Enslim Bader and Raspe versus Germany from 8th of July 1978. I think that was a good law. Disregard of principle of innocence could not be invoked in respect of the present case. The guarantee secured by Article 3(2) devolved upon the court upon try the charge. To the extent that the campaign, now we talk about then decades, already dead applicants who were found dead in their cells in the morning. The court said, according to the government, account must be taken in the context in which statements were made. And there were really statements like bandits, criminals, gang of murderers. And the court observed that the press, even the authorities responsible for crime policy, cannot be accepted to refrain from all statements, not about the guilt of the accused persons, but about their dangerous character where uncontested information is available to them. They were tried by professional judges, not by a jury or media. And this case of the court shows us two things: gravity and magnitude of the crime, and the trial of a public figure creates a legitimate realm for Article 10 rights on those who express an opinion on the case at hand. Furthermore, the timing of assertions made by the politicians referred to by applicant in their annexes should be taken by caution by the court, because in case of Konstas versus Greece, the court said, first of all, that the offending remarks were made after the applicant had been convicted at first instance, and while his appeal was still pending, should be taken into account. And the court sets the principle. On this point, the court considers that Article 3(2) of the Convention in no way prevents the competent authorities from referring to the applicant's existing conviction, even though the question of his guilt has not yet been definitely resolved. In this case, this is not a big issue. They refer only to statements by politicians between the first instance case and the Court of Cassation's case. and in one of which the head of state was asked by an international media outlet regarding this case, and he responded, Turkey is a state of law and this is the matter to be dealt with judges. This is just a tiny example for you to check the annexes carefully. I should also note that the fictional works or the newspaper's interest was sparked by the trial of a public figure. So this should be also taken into account by the court when assessing the impunged assertions. Witness. The government points out that the guarantee secured by Article 3D does not embrace the unlimited right to accuse to call any person he wished to as a witness, nor the possibility of calling witnesses on subjects which cannot help to elucidate the truth. And the requesting the hearing of witnesses at the last hearing was regarded by the Turkish court in accordance with the relevant provisions of the Criminal Procedure Act, was considered as an attempt to prolong the trial. Lastly, I would like to draw the court's attention to the claim of flagrant denial of justice. I would like to refer here Wilcox and Harford versus United Kingdom. The court has indicated that flagrant denial of justice is a stringent test of unfairness. It goes beyond mere irregularities or lack of safeguards in the trial procedure, such might result in a breach of Article 6 if occurring within the contract state itself. What is required is a breach of the principle of a fair trial guaranteed by Article 6, which is so fundamental as to amount to a nullification or destruction of the very essence of the right guaranteed by Article 6. These includes in absentia with no possibility subsequently to obtain a fresh determination of the merits of the charge, a trial which is summary in nature and conducted with a total disregard for the rights of the defense, and detention without any access to independent and impartial tribunal to have the legality of the detention reviewed. The deliberate and systematic refusal to access to a lawyer, none of which were the cases in the present case. So regarding a particular judge, they keep referring to this judge. There are some factual issues. That judge was a pre-candidate in 2018, not in 2023. And it is forbidden in Turkey by law. We can furnish the court with detailed information that any judge, after entering into service, can not do politics. This is forbidden in Turkey by law. But if you look at comparative criminal procedure law, such as Germany, having a political association or being a member of a party do not constitute on of itself as a recusal ground. So, our mother law in criminal procedure law is German Criminal Procedure Code. That's why I'm referring to the recusal grounds from that particular jurisdiction. So this is, by the way, this amounts to, in our view, to judge profiling, looking at the very distant past of a judge, and this is criminalized in certain jurisdictions. And it could be considered as an intervention into the independence of judiciary. So, and there is no indication in the case that his remarks were anyway, in any shape or form, aside from that in distant past pre-candidacy, no concrete, reliable evidence. Otherwise, we are so sensitive about such things. So now I can One more last argument regarding the applicant's claims. This notion of violence stems from the 19th century. And it was really dressed up for the violent uprisings in the European history or in our history. And like our Greek neighbors, we had the problem of juntas. There is no mistake in applying such offenses to junta or military coups stemming from military. But this offense is not only confined to such cases, and physical force against the members was neither necessary nor appropriate. You know, they were expecting a siege of Ankara, the Prime Ministry, or the Grand National Assembly. That kind of, marching towards Bastille is something something from the past. You know, today's subversive acts or such enterprises, insurrectionary enterprises, are sort of a cocktail of at least what we had in Gezi. On the one side, you had the traditional terror organizations who did their job, violently, Molotov cocktails, everything possible. This is well documented in this judgment. On the other hand, we have this modern, foremost disruptive methods. They are recently introduced into English public order legislation. Wearing masks in order to be not to identified or an occupational movement, as we see in Gilets jaunes. So that's why approaching this case from the classical perspective of a coup d'etat would be misleading. So we have also an abundant case law in that regard, and that there is no organization required or that endangerment of this violence is required. And the suitability of acts, I'm here referring to Italian colleague Padovani. The suitability of acts constituting the conduct translate into their capacity to impede the functions of the aforementioned organs. Impedimento, is understood not only as an obstacle to exercise of the function, but also compelling the organ to act in one way rather than another. So just wanted to draw your attention to how to look at this offense, not from the lens of only the applicant or the government, vice versa. Just look at from the perspective of comparative law and the criminological core of such offenses at issue. They refer to a certain group who not once or three times attacked the Prime Minister's office and then acquitted. And this is, at first sight, may seem an contradiction in terms, but the acquittal decision concerned only that persons, and this offense, as stated in the relevant court decision, is they were within the collective planning carried out under applicant's control. They may constitute an important element. So our point is not he mobilized them. Our point is what he said. Let's use this mob. Let's set this up in such a way that if we can organize it, the public power of this will of the charge, the named fan group. So he was using this coercive effect of that particular group, and these are all in the transcripts of the present case. So this interpretation of the offense is also well justified by the prior case law of the court. Now if I may, want to come to the judge's questions. Judge Bertsen, first question. Honorable Judge asked about the urgent appeal policy of the Constitutional Court. Pursuant to Constitutional Court's plenary session decision dated 31st July 2025, 7 distinct categories have been established for the review of the individual applications. First of these, the categories outlines the criteria for files to be designated as urgent. Accordingly, serious and urgent cases concerning the applicant's life or health, serious and urgent cases related to applicant's personal and family circumstances, serious and urgent cases where the best interests of child are at stake, applicants falling under Article 73 of the Constitutional Court's internal regulations, cases where detention continues despite the statutory detention period having been exceeded, applications alleging non-execution of the Constitutional Court's ruling on a violation in the relevant application, cases involving serious violations of the right to fair trial, and the statistics, these are only provisional. We will provide further details in written submissions if we are allowed to do so. It appears that prior to the applicant's petition to the Constitutional Court, 24th of October 2023, approximately 1,860 individual applications containing similar complaints were pending. The fact that the Constitutional Court has not yet ruled on these applications either, along with the applicant's case, demonstrate that the applicant's case had not been deliberately delayed or that the applicant has not been subject to discriminatory treatment. We have further statistics, but we will, I think it's better to provide them because there are many numbers. I don't want to confuse the courts. One of the co-accused, there is a Constitutional Court case about him, and he invoked one of these urgency reasons. He said he was in ill health and his application was duly considered by the Constitutional Court and delivered a judgment. This question regarding life imprisonment without parole, the applicant did not raise it before the Constitutional Court, his complaint alleging a violation of Article 3 of the Convention on account of the absence of a possibility of conditional release. In its previous case law, the Court has acknowledged that the individual application to the Constitutional Court constitutes an effective remedy. And regarding the specific case, there has been no application concerning life imprisonment without parole, and that has been declared inadmissible for this reason. However, it is also the case that Constitutional Court has not to date delivered a finding of a violation in such cases. And this case is not only in the Turkish context. I would like to refer to the sea change from Winter to Hutchinson. This is the life imprisonment of parole is, I think, is a hotly debated issue. And Judge Cook's question, the President appointment of... Now, I have a very detailed briefing here regarding the state of Turkish judiciary. I will also hand over our dear Human Rights Commissioner. Just one paragraph from that. Over the past 20 years, the structure of Council of Judges and Prosecutors has been reformed twice. Through these changes, the number of members were increased. The representation of lawyers and academics was ensured, thereby strengthening its pluralistic composition, and the General Secretariat and the Inspection Board affiliated with were established. At the same time, an independent budget was allocated to this Council, and many powers previously held by the Minister of Justice were transferred to it. And there is an internal effective appeal mechanism was introduced. Taking into account the recommendation in 2010, Venice Commission report regarding the fact that members of the Judicial Council were not elected by the Grand National Assembly of Turkey, there was a constitutional amendment took place in 2017, and stipulating that the majority of members must be elected by the Grand National Assembly of Turkey. Regarding the disciplinary measures, concerning the judges involved in the first judgment. And this case was investigated upon the calls from the public to look into the details of the case. And for 7 hearings, the judges considered the available evidence sufficient, but only decided on the last hearing that it was not. And in the same investigation, based on the witness statements and his own qualified admissions, the judge GMP expressed his opinion about the prejudgment. So he said what he's going to deliver as a judgment in this case, and this concerns about raised concerns about his procedural impartiality and whether he conducted his services consistent and diligent manner. But there is no result from that measures. He is still a judge, acting judge, and there were no punishment or any other sanction imposed upon these judges. And there is no criminal proceedings which has been initiated against the members of the Constitutional Court. But I can tell you something more of nature of general remark. After we introduced in 2010 this individual application, and the Turkish court has become the sort of the Turkish Strasbourg, if you like it. We have this since 19th century we have Conseil d'État, adopted from the French model, and the Court of Cassation again from the French. And, until that time we didn't have this review mechanism. And who has the final say about the criminal outcome? We have this grappling, I think, which will be resolved in time, but it's not an easy case because even in those countries like that of Germany, where they have since longer time established individual complaint mechanism, there are criticisms of this superrevisions instance, etc. And same, we have exported or imported the same discussions into the Turkish legal system. It might sound chaotic, but no mala fide can one deduce from that, or should not deduce mala fide from that. It is imperfect. Regarding the Article 5.1a, the government considers that the relevant period for the applicant's complaint should be regarded as 15-month period between the 9th of June 2002, the date on which the applicant lodged an individual application before the Turkish criminal procedure, and the 8th of September 2023, the date on which his conviction finalized. We consider the 15-month period elapsed before the Constitutional Court should be considered, and it's reasonable. So, if I'm not mistaken, I try to respond to all questions, but for the sake of completeness, we can furnish the court with written further answers. Thank you.
Thank you. I now call Mr. Leach or Mrs. Chali for the applicant side.
Thank you, Mr. President. I will first respond to some of the judges' questions, and then, with your permission, I will hand the floor to Professor Chawla. To Judge Bardson, your question about priority policy was aimed at the government, just to underline the fact that Mr. Kavala did invoke the priority policy at the Constitutional Court, but to no avail. You then also raised the question about Article 5.1a, to which the government has responded, this flagrant denial of justice test. So we have, just to be absolutely clear, we've very clearly pleaded a violation of Article 5.1 from the outset, and the 15-month period that the government refers to is too long. That's our case. But the period extends beyond that, we say, because the conviction does amount to a flagrant denial of justice. You heard some of the definition from the UK case that the government mentioned, he was right to say it's a stringent test. Of course, it's a stringent test, and that it goes beyond mere irregularities. That's of course, true. Both of those are applicable to Mr. Kavala's case. It was most recently, the flagrant denial of justice test was most recently defined, as far as I'm aware, just a month ago in Navalny number 4, where again the court there said at 134, a breach of Article 6, which is so fundamental as to amount to the nullification or destruction of the very essence of the right. That was the way in which the court defined it, and they gave some examples, one of which was a summary trial conducted with a total disregard for the rights of the defence. That, we say, is very obviously applicable to Mr. Kavala's case, given not only the 2019 judgment, but also the 2022 judgment, the statement in 2022 by the Grand Chamber that the actions of the authorities vitiate any actions in proceedings in relation to either the Gezi events or the attempted coup. And we say there has been a violation of Article 6 taken together with Article 18 in this case. Then, if I could go on to the question from Judge Yüksel, we were asked why was no new application introduced to this court after the December 2020 Constitutional Court judgment. Why was no application brought at that stage? Well, it's Mr. Kavala's arbitrary and unlawful detention is a continuing violation of Article 5, and therefore the time limit for lodging in Strasbourg has never started, even today. Of course, the government say we're in lodging in 2024. We're still far too long, a point that we have clearly rejected. To Judge Kutz, your question about Article 5 and the issue of execution, and whether the court should be able to look at that. So, again, to be absolutely clear, this case is about the new and ongoing violations since the court's 2019 judgment. There's an ongoing violation of Article 5 and new violations in relation to Article 6 and other provisions that we've referred to. But you ask about the issue. So this isn't, as we've said very clearly, I think it's not a case about the implementation of that earlier 2019 judgment. But of course, as we've said, the findings of both the 2019 judgment and the 2020 judgment are essential context to this case, as also the Commissioner for Human Rights has said today. We have referred in our written pleadings to comparable examples in some of the Russian cases where the court has had to look again. So the Chechen cases, Isayeva, Abuyeva and Abakarova, and the court looks again. So there's a comparison there because it looks again at the same violation in 3 successive decisions relating to different applicants, and and the court says very clearly that we need to go beyond the previous decisions. There should be additional consequences to the government's non-compliance. They say in Abakarova in 2015, it demands actions over and above the previous judgment. So that's one of the reasons why we say, in addition to calling for his release, which the court has already ordered, directed several years ago, that is also why we request a specific provision for his acquittal or nullification of his conviction. And there is ample case law at the Inter-American Court of Human Rights in which the Inter-American Court has done just that. And we can provide the court with those cases if that's of use. Then in relation to the question from Judge, I'm going to leave that to Professor Chawla. I have one other point before I hand over, which is in response to the what the applicants have said in relation to Article 18 and Article 7. So we have pleaded Article 18 in conjunction with Articles 5, 6, 7, 10 and 11. Now, in relation to the application of 18 with Articles 6 and 7, there's been some uncertainty of that. We now know, of course, from the Ukraine, Russia, the recent Crimean Grand Chamber judgment, that Article 18 applies to Article 6. But they do say, which we have dealt with, that Article 18 doesn't apply to Article 7 in that case. And we do ask this Grand Chamber to look again at that point in the particular context of this case. It's dealt with in that case. It's an interstate case, of course, about the Russian occupation of Ukraine. It's a very, very different context. And it's the actual 18 and 7 point is dealt with within 2 sentences. The reasoning is that Article 18 shouldn't apply to Article 7 because it's non-derogable. It seems to us that that doesn't necessarily follow. And in this case, it follows on from the application of Articles 18 with 5 and 6, so the pre-trial circumstances and the conviction circumstances. If you take a holistic interpretation to the Convention, it seems to us only logical and right that Article 18 should also apply to Article 7 and not to preclude that possibility. In this particular case, we say that Articles 309 and 312 of the Criminal Code were deliberately applied to Mr. Kavala to silence and punish and target him. So in that context, we do ask you to look again to apply Article 18 to 7 and to find a violation. Mr. President, with that, I will, with your permission, hand the floor to Professor Challa.
Thank you. So I now call Professor Chali just for the next step of your reply.
Thank you. Thank you, Mr. President. Let me just carry on answering some of the questions that we've received from the judges. One of these questions was about whether there was any effective remedy in relation to Article 3 concerning the review of aggravated life imprisonment. Now, to our knowledge, there is no Constitutional Court case law that would make the Constitutional Court an effective remedy in relation to that very specific question. We're not aware of it. We're aware of the Tekinen Baysal decision of this court, which suggested that it may be, but as it was also underlined, there is no case law that we would be able to show that this has actually been an effective remedy. But in any case, as we have pleaded before this court, there are exceptional circumstances as to the effectiveness of all domestic remedies as they apply to the Constitutional Court in this case. And I'd like to underline that we're talking about the circumstances we've outlined in relation to this case. So we would say that in any case, it would not be possible to assume that there will be a remedy, both because there's no evidence of it, but secondly, because of the special circumstances in this case. Now, secondly, we also would like to point the court to its recent judgment in Boltan versus Türkiye in 2019, which is a violation judgment exactly on the same grounds. And in this case, the applicant did not exhaust the domestic remedy before the Constitutional Court, and this was not contested by the government in these proceedings, which this court clearly underlined, which was the case. In our submissions, we were guided by Boltan, which is the latest decision of this court of 2019 in relation to this case. Now, Judge Mercer was asking about the procedures before the Turkish Constitutional Court, and I understand that the question concerned the October application and not the June application of 2022. Before I come to that, I'd like to underline that we have learned also ourselves from the government submissions that Mr. Kavala's third application, which was launched in June 2022, was suspended on the 25th of July 2023, which is a few weeks after the infringement judgment of this court. Now, all of the proceedings in that first application were completely completed, and that case is, as we were informed by the applicants, by the government submissions, is suspended, and I'm not aware of the procedural explanations as to why that may be the case, and we were not informed about that. In relation to the fourth application, every single submission stages, the replies by the government, all of this have been completed months and months ago, so the only procedure that's remaining is the delivery of judgment. But I must underline that this is the only procedure remaining for the third application from 2022 June, as well as the fourth application from October 2023. I think this concludes our answers to the questions. Of course, we're very happy to answer any questions that may need further clarification. Let me also refer you to our detailed submissions to this court, both in November of last year and also February of this year, which we have detailed quite a lot of the issues. But let me just underline a few things in response to the government's submissions. Now, one of the points that was raised was in relation to the fourth instance doctrine, which this court is very familiar, as well as many other courts in Europe and on this planet. And of course, the question of the review of evidence comes in a very special way before constitutional courts as well as before the European Court of Human Rights. In order to assess whether the Convention rights are protected, this court and any other court in the Council of Europe member states, any other apex court, must examine the relevance and sufficiency of the evidence in the light of the standards that are set by this convention. And I think that this is the task of the court to do so, and this is not an ultra vires act of looking into any fact-finding, but it's the review of the relevance and sufficiency of evidence, be it for under Article 5, Article 6, Article 7, and so on. So in this regard, we must underline that this type of argument that the evidence cannot be reviewed has also been used by the Court of Cassation, who initiated a criminal complaint about 9 judges of the Turkish Constitutional Court precisely on this point, that they were looking at the relevance and sufficiency of the evidence, and this was made a basis of a criminal complaint by a Court of Cassation against the Constitutional Court of a country, which speaks to our earlier submissions on the effectiveness of these remedies. Now, a second point that came up was on the principle of subsidiarity, a very important principle of the European Court of Human Rights, which is also obviously in the preamble of this convention. Now, there's a lot of very important pronouncements on what principle of subsidiarity is. I'm usually very much impressed by paragraph 189 in Savran versus Denmark, the decision of the Grand Chamber, which I think very clearly explains the meaning and application of proportionality, which in this paragraph, of course, this court says that this requires an independent and impartial court to have carefully examined the facts, applying the relevant human rights standards consistently with the Convention, and adequately weighed up the applicant's personal interest against the more general public interest in a case. So these are the qualifiers which were established in very clear crystal terms about what it means when we value, cherish, and respect subsidiarity. Similarly, in ZK versus Turkey, this court has underlined that there are 3 very important considerations about the applicability of the principle of subsidiarity in relation to Article 35 of the Convention. So the first test this court has established is whether the Constitutional Court's decisions have a binding nature. We have argued that in this case, this is not the case. It's highly suspect. On 3 occasions, the binding nature of the Constitutional Court judgments in relation to Gezi Park protests were denied by lower instant courts, and on 2 occasions by the Court of Cassation. Test number 2 is whether the individual claiming to be a victim is testing the limits of the protection provided by the remedy before the Constitutional Court. Mr. Kavala has lodged 4 complaints before the Turkish Constitutional Court. 2 of them were unsuccessful, and 2 of them have still not yet been decided. And he is unlawfully incarcerated now for 8 years and 5 months. And number 3, the final test is that this court reserves the right to examine the consistency of the Constitutional Court's case law with its own in its assessment under Article 35. Now, the Constitutional Court did not provide a remedy in the first judgment. In the second judgment, it had the opportunity to review and take into account the findings of the European Court of 2019, and it did not do so. In the judgment that came out as an 8-7, the majority of the judges did not take into account the case law of this court, and this was acutely underlined by the dissenting judges, which during the infringement proceedings, the Grand Chamber also underlined in a very systematic fashion. Now, just 2 additional points that I'd like to raise. One of them is the characterization or the description of the facts and the contestation around what the facts are. Was this a protest? Was it an insurrection? Now, we have used official reports by the Turkish Human Rights Institution, which is an interstate, intergovernmental human rights institution, which we have annexed to our submissions as to the establishment of facts. So we are relying on the report of the governmental human rights body in relation to the Gezi Park events. In addition, we have also made use of the report of the High Commissioner for Human Rights, who have done country visits and reported on them. So in our submissions, we are guided by these 2 fact-finding reports that were established by a governmental body and the Council of Europe High Commissioner. The second in relation to the facts is there was a lot of mention of material and financial support in relation to the criminalization of Mr. Kavala. And with the domestic lawyers who have been following this trial for the past 8 years, we've gone through this information once again. And here, what is also mentioned in the Court of Cassation judgment as material and financial support are 20 sandwiches, 20 COVID face masks, I shall correct, not gas masks. These are face masks that we all have worn, and the number of these are 20, and they were bought from a pharmacy. 20 poğaça, these are cheesy cheese pastries, they're very nice. 1 foldable plastic table, and 1 loud speaker that went into the park when people were protesting in the park. I must underline that Osman's base, or Osman Kavala's office, is at this park. So this is his workplace. And when these protests, environmental protests to stop the building of a shopping center in the only park in that square started, this is what he has said that he could do. And the amount, the inflation in Turkey is very high, so I will get this wrong. At that time, it was 670 lira. We think this is, and I may be wrong, I apologize for that, it could be about 300 euros or less. This is the material that is in the Court of Cassation judgment and was repeated here that was provided by Mr. Kavala. In relation to money transfers to his not-for-profit organization, Anadolu Kültür, and this is also constantly repeated in the Court of Cassation judgment, as you may have seen. This organization has been vetted regularly and continuously, and also very recently during this whole proceedings, and had a clear report from the Ministry of Trade about that there was no irregularity in its finances, in its books and papers, and we have also submitted that to you as an annex of the most recent vetting of this, which has happened prior to the Court of Cassation's judgment, so this knowledge was publicly available of the vetting of that information. Now, finally, there are these recordings, the tapes, that he was speaking to people on the phone, organizing activities. it is incredibly crucial that Mr. Kavala never had a chance to listen to these recordings. He was not able to evaluate the evidentiary value of any of these conversations that he had. And in effect, we are talking about his conversations with 10 people in total within a space of a few weeks. And this was requested throughout the whole trial, that he'd like to listen to what was recorded, and he wanted to challenge, what the meaning of these terms, because the meanings are attributed by he said this and he said that. And throughout this trial, he was not given an opportunity to actually challenge and question and examine these recordings that are now in front of you as transcripts after transcripts. None of this has been reviewed under the equality of arms principle throughout the trial. And I think this is another additional factor of the serious breach of Article 6 in this case. And of course, there has been a long discussion in the domestic courts that these were unlawfully acquired wiretappings, and this issue also has been raised and has not been answered in the Court of Cassation judgments. We do not have any information about the 3 judges who released and acquitted Mr. Kavala. The reports and the disciplinary investigations of the High Council of Judges and Prosecutors is private, and we were not provided that information, so we will not be able to comment on what happened to those judges, how they were investigated, what they were, accused, what kind of indisciplinary conduct. None of this information is something we can verify, we can read, or we are able to comment. We are not able to have access to that information. Thank you.
I thank you for your submissions. At that stage, yes, I want to know if some judges wish to ask for clarifications of the answers which were given by the parties' representatives. Judge Chanturia, and yes, please.
Thank you, Mr. President. Small clarification. If I correctly understood from the government's representative, there were no specific reasons justifying the suspension of the proceedings.
Yes, please.
Can you repeat the question?
So I asked whether there were reasons justifying such duration of the proceedings. There were 2 applications still pending. And my question is, so if I correctly understood that there were no specific reasons justifying the suspension of the proceedings.
Is there a suspension of proceedings? There is no publicly disclosed reason for that, but I can, yeah.
Okay, thank you. Judge Kitsakis as a follow-up of answer given, not another.
Of course. Okay. My follow-up is to the question raised by colleague Kutz, and I want to give the opportunity to the government to clarify the following. Are the criminal proceedings against the 9 members of the Constitutional Court still pending today? Thanks.
There were no such proceedings, I have told, but we can furnish you with the detailed information. So no, there is no such no initiated criminal investigation into the judges of the Constitutional Court. I think it would be a misunderstanding. But we can provide the information, if you like, in written form, because okay. I'm not aware of such an information.
I say. I would like just to make a point. Both parties, if they wish to do so, and it has been requested by the government, will have the possibility to provide written observations within 2 weeks. And for any kind of precisions, clarifications, or further elaboration of your answers for both parties within 2 weeks. Any other request for a clarification or follow-up? No? Well, we have now come to the end of the public hearing. I thank once again the parties for their submissions, for their answers to the court's questions. And the court will now deliberate on the admissibility and the merits of the case. The judgment will be delivered at a later stage, and the parties will be informed on the date of the delivery. And having said that, I declare the public hearing closed.